release me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Speak low, stand in your row, try not to show this life's a show. Try not to glow. Way down below, it's a lot of woe. And that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you now to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true,
Hi, you guys. Good afternoon. How is everybody? I hope everyone's doing well, especially after yesterday. My goodness, yesterday was a day, wasn't it? Donna and her histrionics. I can't. Okay. So today, what's going on is the Megan Boswell sentencing. And you guys might be asking yourself, why are we doing sentencing? I thought she was sentenced. She got the jury recommended life without the possibility of parole, or life with the possibility of parole, after 51 years. So what's left? Well, Megan was also convicted of 19 other sentences or 19 other crimes, related to Evelyn's murder. So that's what they're going to hear today. But let me say hi to you guys first, and then we'll get into it because we still have a little bit of time before the hearing is supposed to start. So Nadine, my boo, good to see you, babe. The boss lady. Jeffrey, good to see you. Gretchen, hey, good to see you guys. Preschool Granny, hello. Jen says, I'm going to try and watch, but I'm at the ER. Oh, no, babe. I hope they get you taken care of and you get better and feel fantastic. Hey, Lil Red. Hey, Kelly. Good to see you guys. Hey, Tracy, Mally, Crafty Chris, Hilson House of Crazy, Creative Minds. I have the hiccup, so please excuse me. I'm sorry if I hiccup in your ear. I'm not trying to. Hey, Melissa McCoy. Good to see you. Hey, Chief. What up? Let's go. Hey, Neat Noodle. How are you? Crocheting Bammy. Sprinkled Donut. Hey, J Rose. Hey, Violet. Check on lady. Good to see you. Justified. Hello. Just want to make sure I get to see Demony dear. Hey, good to see you. Hey, Sarah Bellum. A million sparkles. Hello. All right. So, guys may be wondering, like I said, what's left? All right. So, yes, there's the 19 other charges that she was convicted of. That's number one. But number two, even though the jury recommended life with the possibility of parole after 51 years, right? The prosecution feels, and I have to agree, that Megan's crime, the totality of all of the circumstances, the lies, the way that she disposed of Evelyn's body, just all of it, okay, makes her a continued threat to society. So, along with being sentenced on those other 19 charges, really what the prosecution is going to do today is present aggravating factors and recommend that she serve all of her sentences consecutively, one after the other, rather than, oh gosh, what is the word? Why can't I ever remember this? Concurrently, which means she'd be doing all of the sentences at the same time, not one after the other. They want her to have those, they're going to recommend it to be consecutive because that would effectively cancel out her possibility of parole, even if it is after 51 years. And so that's really the evidence that they're going to present, all of the aggravating factors and why the judge should sentence her, should make her sentences run consecutively rather than concurrently. And then obviously on the other side, the defense will be presenting mitigating factors, to show why they shouldn't run consecutively. They should run concurrently. And Demony Tier. I always want to pronounce your name like Domini Tier from Damien's baby mama, but it's Demony Deer, and I can't, for whatever reason, my brain is not going to let me say that today. So I'm going to continue to practice it in my brain prior to saying it out loud, and hopefully I do not mess this up anymore because I don't like to do that. But wants to know if victim impacts statements are today also. Yeah, I think they would be. I would imagine that they would be presented today because I would imagine that those are going to be, part of the potential. That the judge is going to want to hear from the victims about how this Megan's crime and Evelyn's murder has impacted them, and I hope that they do decide, that the judge does decide to have the sentences run consecutively rather than concurrently. But I will say this, I'm a little bit apprehensive about that, and here's why. Megan is chronologically, she's young, and there are people who hold out hope that she can be rehabilitated and no longer be a threat. And the fact that it's going to be 51 years before she's even eligible for parole. Let's be realistic here. So eligibility for parole, think Diane Downs, Susan Smith, Just because somebody is eligible for parole doesn't mean that they're going to get parole. There's all manner of factors that go into it. Even the Menendez brothers, they were eligible for parole, and they were denied parole. And part of the reason that the parole board gave for denying their eligibility, for denying parole, not their eligibility, but for denying parole, was based on some of the their behavior while they were in prison, while they've been in prison. So, there's a lot of things that go into the factors of whether or not somebody just will be getting parole. I mean, it happens all the time. People will come up for parole, and for whatever reason, or multiple reasons, they're denied parole. And the other reason why I am kind of thinking that it might not go consecutively, even though I think that's what she deserves, why the judge may rule on concurrently, is because after 51 years of being incarcerated, at that point, she'll no longer be able to have children. And so I think the thought is that she'll no longer be a threat. I disagree with that. I think that just because she cannot have children biologically anymore at that point, the odds are, right, that she couldn't, doesn't mean that she's no longer a threat. Megan is a prolific liar. And the abuse that occurred to Evelyn, I don't believe was just a one-time thing. First of all, we have neglect. Neglect, in my opinion, and I believe in the eyes of the law, is abuse. When you don't keep the home where your children reside clean, and we're not talking about, listen, I'm not talking about up to my standards of clean. Okay, I have some issues that make me probably clean excessively. Okay, so I'm not even going to say that she needs to have, up to my cleaning standards. Okay, but that home was filthy, hoarder level filthy. Okay, and no child that's not safe. Okay, that's not safe for a child to live in, that level of filth. Then you have on top of it, like the country life of, or the chicken lady has mentioned, the diaper rash that people kept talking about. Absolutely. I mean, there were many, 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 many red flags about the situation that Evelyn was living in, and none, for whatever reason, she fell through the cracks, which is another conversation entirely, right? Because like, it's gross, and it's a problem. We have a huge problem in this country with that. I want to say hi to hold on, where is she? Where is Rachel and Tess? Hi, Tess. Hi, Rachel. I can't highlight your comments for whatever reason, because I don't want to just sit here and have, nobody speaking, just, quiet. But hello, I see you guys. Thank you both for being here. I appreciate it. And Gretchen, good to see you as well. The spoiled milk, the trash. I mean, that trailer was absolutely disgusting. I mean, the fact of the matter is after Megan moved out of that trailer, her family hired somebody to come in and clean up that trailer. And, they had to do quite a bit of work to that trailer to make it in any way, shape, or form livable after she'd been there. I mean, they had to replace the flooring, vinyl flooring. They had to replace the carpet and the pad and likely treat the subfloor. You know, that's substantial filth. Okay, we're not. You know, it was just filthy and disgusting. You know, yes, Demony, the cleaning, the guy that came in and cleaned wore a hazmat suit. Yes, yes, it was terrible. He had that respirator on and everything. It was, disgusting. And no child deserves to live like that. Hey, Allie, good to see you, babe. Um, so yeah, you know, we don't, I can't, I wish I could find a different, um, why is this doing this? What the hell? Hold on a minute. I guess it's just a glitch in the matrix. I really would like to find, I don't want to stream court TV, quite honestly, but I'm really struggling to find um, I'm trying to find the stream that is likely from the news, and I just can't find it. It's very disappointing. Maybe court TV is the only pool. But if that's all we have, that's all we have, and I will, make the best of it. Um, I am kind of curious also, like, I know I already talked about this, but I am still kind of curious about the victim impact statements, because I know that there were a few people that testified for Megan after she was found guilty. And when the jury deliberated her sentence on the murder charge, and her grandmother spoke, her mother spoke. So I don't know if, oh, awesome, Rachel. I can hardly wait for Boone versus Boone. I feel so awful for Brian in that situation. She's a monster. She's just a different kind of monster. Hey, ATS, good to see you. So let me just show this on the screen. They haven't started. I mean, court TV is live, but the proceedings haven't started. So there's that. Also, this weekend, at some point, I'm still working out my schedule. I do want to do a members only live. I got a lot of things that I want to talk to you guys about. And I also want to show my appreciation for the years and months that you guys have supported me, and I need to give back. I'm still working on the second part of that documentary. It's taking me a lot longer than I anticipated because I have to be really careful. There's things that I need to use from it that are definitely copyrighted material, and I feel like there's a way to do it. I just have to, I have to keep uploading it and then seeing what the copyright claim is, and then, working on it again and all the things. So, hey, proud grandma, good to see you. Thanks for being here. And preschool granny, wow, thank you for being a member for 20 months. I appreciate that so much. Thank you, thank you, thank you. Also, I just want to talk to you guys about some things. I want to talk to you guys about, what I want to do with the channel, where we're going, all the things. So, all that. And I just want to give back some thanks. Oh, thank you, preschool granny. I'm glad you love it here. I try, but truth be told, me as a channel holder or channel owner is like just a small portion of what makes the channel great. I think what really makes the channel, and particularly the lives, so wonderful are you guys, really. You guys are very welcoming to new people. We don't always agree on all the things all the time. I don't want an echo chamber. That would be so boring for me. I do love a good debate, what I appreciate about you guys is that we can have that debate. You guys can have the debates in the chat, and yet it doesn't devolve into name calling and, just going real life and just getting hood and getting, crazy about it and just, you know, being a mess, a dumpster fire. But I don't want that for the channel. I really don't. Like, I don't need that headache. I don't need that headache at all. But I do need for them to get this underway because I'm antsy about it. I'm having a hard time getting comfortable in my chair because I'm antsy about it. And my little chicky nugget wants to come over as soon as this is over and play her Bluey game. She just loves that game. And you guys, I'm so proud of her. She's gotten so good at it. Like she needed a lot of help in the beginning when she first started playing. But now she's like, I can do it, Granny. I can do it. Look, I did it myself, Granny. And I'm so proud of her. She just, I love that when she, those little moments of accomplishment, they're important. They're important. Oh, well, thank you, Tess. Tess says, but you, Allie, MJ, and Amber set the tone and energy. So you definitely have an impact on your chat and community too. The word, it's a rarity, but you guys are doing it. Yeah, thank you. Thank you. I will agree. Allie, MJ, and Amber also have great communities, great chats. We share a lot of subscribers, and we just, we're very, very, very lucky. We have a really great community, and I'm just really grateful for it. So I want to talk to you guys about some things, but I also want to make it like fun. I was thinking, what if we did, an open panel and you guys could come up and talk. Now I'll say this, because it's easier, okay, for y'all, I will make the live scheduled through StreamYard because StreamYard's platform is more user-friendly, and it's what most people are used to. So I will go through StreamYard to do the live. Just because the only bummer about that is I can't, I have to I don't know how I'm going to do this. I'd have to probably upload my intro. I think it's already up there on YouTube, and then play it from there. No biggie. And I think I would be limited about how many people I could have on stream because I'm not paying for StreamYard at all. It's expensive, and I just don't think you get as much out of it, quite frankly. So I don't think it's worth it. So I'm just going to use the freebie. Just means I don't have as many extras, and bells and whistles, but that's all right. I'll figure out a way around it. It'll still be fun, even without all the bells and whistles, right? So, and I do want to have, I want to talk about, we talked about, at the end of last month, doing a members only live stream, just talking about, food, snacks. You guys know how much I love snacks. They're a priority in my life. Snacks and naps, although naps, not so much. Excuse me. I'm sorry for the hiccups. Naps are not something I get as often, but that's fine. I'm a grown up and I shouldn't need as many naps anymore, but whatever. Hey, Kimberly, good to see you, babe. No, you haven't missed anything. They haven't started. Let me just see if I can still find another. There's got to be. There has got to be. Let me try it this way. Let me see. Somebody else has got to be. Let me think. Let me see if I can find it. Let me try one of the news stations. Give me just a sec. I mean, they streamed her trial. So certainly, and they don't have a live scheduled. All right, hold on. Don't you guys worry. I try not to stream from Court TV just because I don't know why. There's a lot of like, let me see. All right. None of the local news channels are streaming it, so I'm thinking that Court TV might be the pool feed, and so we'll just have to deal with it. There you go, Kimberly. Snacks, naps, and songs about kitty cats. Yeah. Speaking of kitty cats, oh my gosh, you guys, Mac is out of control, y'all. This cat, I swear, at 7 o'clock, I don't know why it starts at 7. This tells me that cats do have some concept of time. I give them their treat at 8 every single night. Sometimes it's 8:01, okay? But there it is. At 7 o'clock, he starts with the screaming at me. Oh my. What's happening with the, what are we using to film this? Is it just me or is it like super blurry?
State versus Megan Boswell, 72869. We're on today for sentencing. There was a pre-sentence report.
I would just like to say I'm personally grateful that Megan has not worn that bow that she did on the last day of her trial. That in and of itself should be an extra charge, carrying an extra sentence, I feel. But I am grateful she's not wearing it today. I see that she has taken the approach of many people after conviction and and everything, and decided, long hair, brush it, don't care. Okay.
For the 4th, 2025. A jury convicted Ms. Boswell of first-degree murder in count 1, first-degree murder in perpetration of felony in counts 2 and 3. The jury sentenced her to life. The jury also convicted her in count 4 of aggravated child abuse, count 5, aggravated child neglect, count 6, tampering with evidence, count 7 through 17, false report, count 19, abuse of corpse, count 20, failure to report a death under suspicious, unusual, or unnatural circumstances. So we're here on counts 4 through 20 for sentencing today. Is the state ready to proceed?
We are, Your Honor.
Defense ready to proceed?
Yes, Judge.
Because sentencing, the first thing that's up, the state has the burden.
Judge, how are you going to handle the pre-sentence report that we made?
Because of the nature of this case, it's going to be exhibit number 1. I normally don't make any exhibit, but I think in this case,
Fine with me.
thanks, sir. Somebody have a copy of it? It's not being marked up? And if you don't, I've got it in the file. I just got to find it. Which file it's in?
Judge, we have a clean copy.
Oh, you know what? Our bailiff friend isn't there. We have a new bailiff. What were we calling him, y'all? Carl? Where's Carl? I missed bring back.
Does the state have any proof?
I don't like change. Yes, Your Honor, the state would call Sheriff Jeff Cassidy.
Raise your right hand, state your name, please.
Sheriff Jeff Cassidy.
Solemnly swear affirm testimony about to give the truth, all truth, and nothing but the truth.
Tell the court your name and where you're employed.
Jeff Cassidy, Sheriff of Sullivan County Sheriff's Office.
And how long have you been with the sheriff's office?
Been with them a total of 29 years. This is my 7th year as sheriff.
Okay, and so that means you were sheriff in 2020 during the time of this investigation, is that
Yes.
right?
Yes, ma'am.
And I'm gonna take you back to February 2020. Was Sullivan County the first agency to be involved in the investigation of missing child Evelyn Boswell?
Yes, ma'am.
Can you tell me briefly how Sullivan County how the investigation started?
Missing child at first, and then once we found out that the last time the baby was saw was in December, we knew he was already behind the curve there. We was probably 2 months away from utilizing the resources that we needed to rescue or recover a baby Evelyn.
Okay. How old were you told Evelyn was the time the investigation began?
15 months.
Okay. What was your role in the investigation?
Of course, as a lead agency, I always stay in contact and communication with all my detectives and everybody that was responded to this scene and responded to all the tips across pretty much the region. So, I was constantly in communication with TBI, FBI, and my detectives.
Okay. If you had to give an approximate number, how many Sullivan County employees do you think were tasked with working this investigation?
Aside from my executive staff, which is about 14, we had probably an additional 40 worked around the clock just on this case.
Okay. When you say around the clock, was there 24/7 coverage
Yes, ma'am.
of this? And are we talking about from the day she was reported missing until the day that she was found?
Yes, ma'am.
It's approximately 18 days.
Yeah, from about February 18th to March 6th, I looked through our records, and just overtime hours alone on this case was 740 hours.
Okay. And that's employees working their regular shifts plus overtime?
Plus
essentially.
overtime.
Okay. So, let me ask this first. Did Sullivan County end up requesting the assistance from other agencies?
Yeah, this was a unique case. Normally we work most cases on our own, but we had to pull resources from the Tennessee Bureau of Investigation, Federal Bureau of Investigation, Virginia State Police, SBI.
What is the SBI?
State Bureau of Investigation, and then we had Tennessee Wildlife Resource Agency, and then multiple local regional jurisdictions up in North Carolina and other states in Middle Tennessee.
Okay. And is that essentially from following tips that were coming in?
Yeah, anything that came through, we followed every lead, tried to look into everything that was brought to the VCC, which is the Virtual Command Center through Tennessee Bureau of Investigation.
And is the Virtual Command Center, that's where the tips would come in to decide how to then send them back out to be investigated?
Yes, ma'am.
Okay. With these different agencies and with Sullivan County, what types of resources were you able to, what did you utilize to try to find this baby?
We utilized every resource that I've ever even been involved in that was at our disposal. I mean, we took jets to different places to expedite the finding of any type of information that may lead to the recovery of Evelyn. We utilized everything the TBI and FBI provided us with, just anything that was at our disposal. And we probably used more resources for this than anything I can ever remember.
We know that one of the stories, false reports that the defendant gave was that a person by the name of Ethan Perry had Evelyn. What did you have to do in regards to following that lead? What resources were used?
Yeah, he was in the military in Louisiana, from what I remember, and we had to send some detectives up there as well.
Okay. And we know another story that she gave was that she kept hinting at Mendota, Virginia, over and over. Is that a lead that you also use resources to follow?
Yeah, United States Marshal, I left that out. United States Marshals helped us out on that one in Mendota.
Okay. She also told you that Angela Boswell, her mother, had Evelyn at some point. Did you follow that lead?
Yes, we worked extensively on that one. We thought that she may have had custody of baby Boswell, so we that went into North Carolina, and I think the dive team went into the ponds over there as well.
Okay. So in preparation for today's hearing, you were asked to review Sullivan County records regarding this investigation, is that right?
Yes, ma'am.
And the records that you reviewed, were they all maintained by the sheriff's office?
Yes, ma'am, just the Sullivan County Sheriff's Office.
And the purpose of those was to come up with the manpower that was used?
Yes, ma'am.
To get an approximate amount of manpower and overtime hours, is that right?
Yes, ma'am.
What if the defendant had told the truth on day one?
Yeah,
Objection calls for speculation.
I can ask you a different way. Would you have found Evelyn if the defendant had told the truth on day one?
Objection
Yes.
calls for speculation.
Sustained. Yeah, we need to reframe it. It's too wrong right now.
If you had known that Evelyn was dead on day one, would that have changed the way you conducted your investigation?
absolutely.
Okay. Would all of these resources have been used?
No, ma'am.
Were you aware of community involvement during the time of this investigation, the 18 days of investigation?
Yeah, extremely. They really provided us a lot of additional resources that not criminal justice related, just like they brought us food to the office so we could, eat and still work. And they all pulled together during that time and just showed tremendous outpouring of support for our entire agency. And, across the nation, really, this was a national recognized case. So the people around here in the community, they started Evelyn's Army, and they provided food for us daily.
Based on your own personal observations, what did the impact on the community look like to you?
Very emotional, just like my staff. I mean, everything you see, people wanted to find this baby, and that was their number one goal. And, whatever it may take, whatever it may need, whatever resource may need to be utilized, everybody was willing and able to put in their time, effort, and energy to locate baby Evelyn. Just like my staff, I mean, the emotional toll on them, the lack of sleep, but they never did get fatigued. I tried to send some home, and they said, no, I'm not going home. I'm going to work on this case until we find the baby.
Okay. No other questions? Please
Thank
answer
you.
any questions Mr. Scott has for you.
I don't have any.
So, Diminy Deer asks, this is the same case that the cameraman got thrown in jail for showing attorney screens, right? Yes. Actually, I believe the straw that broke the camel's back was the fact that he showed a juror, more than one juror. I believe it was a couple, but definitely one.
Thank you. Thank you.
State would call, take the math price.
Sit on the swear affirm testimony about to give you the truth, the whole truth, and nothing but the truth. Yes, sir.
You're Matt Price, is that correct?
Yes, sir.
What is your position at the Sheriff's Department?
I'm Lieutenant in Criminal Investigations.
All right. And Lieutenant Price, you very familiar with the investigation involving the disappearance and death of Evelyn Boswell, is that correct?
Yes, that's correct.
What was your role in the investigation?
This case was assigned to me as the lead investigator with the Sheriff's Office. So I was the lead investigator.
All right. And you worked, the Sheriff has testified to, you worked hand in hand with numerous agencies in the investigation, including the TBI, is that correct?
Yes, that's correct.
Okay. And Agent David Gratz at the time, also the two of you
Worked it.
worked extensively, that's
Yes.
correct. You familiar with the evidence that was collected in the case, the discovery of the body of the victim, Evelyn Boswell?
Yes.
Crocheting Bammy says, where was the cameraman from? It was a local news station that was in charge of the pool feed. So it was a local cameraman or person. Also, hey, Alicia.
I'm gonna hand you some photographs. I'm just gonna do this one at a time so we, for the sake of getting these exhibits in, I'm gonna hand you the first photograph, ask you if you can show us, identify what's shown in that photo.
Yes, this is a photograph of looking inside the playhouse at the trash can where Evan was located.
And is that a true and accurate depiction of
Yes.
that scene?
Yeah.
Judge, we would move to make that exhibit number 1 to this hearing, two, I'm sorry. And, I don't know if it's helpful, but that was what the trial was introduced as exhibit number 15. I don't know if that's helpful or would create confusion or.
Let's just still be exhibit 1 for that sentence.
Two. You recognize what's shown in the photographs just handed to you?
Yes, I do.
What is that?
Again, this is looking inside the playhouse at the trash can after the, one of the bags had been removed off the top.
Okay. Is there anything of significance that you see as you look at the trash can itself?
Yes, it appears that the items inside the trash can have been compressed.
Judge, we would move to make that exhibit 3 to this hearing.
Yes, Violet, he did have the glasses that break away. Yep, sure did.
Okay.
Hey, Stars Align.
Take a look at the photographs being handed to you and ask, or again, ask if you can identify what's shown.
Yes, this is a picture of the inside the trash can with the blanket removed where you can, see baby Evelyn's leg.
Is that the first shot or first, I guess,
Yes.
discovery of the body?
It is correct.
All right. Judge, we would make that exhibit 4 to this hearing.
Hang on just a sec. Let me pause this. Stars Align says, is this happening now or is this from the original trial? No, this is happening now. This is live, current. This is her sentencing. But just to refresh you guys' memories, and also I have to pause for fair use commentary. Remember that there was trash on top of baby. There was baby Evelyn was in a trash bag, wrapped in foil. Her body was wrapped in foil. And there was trash in the bag that she was in, but there was also a trash bag on top of the trash bag that her body was in. And she was in the trash can upside down. So I just wanted to refresh your memory. I'm glad they're not showing pictures. I don't think I could do that again, but let's keep going.
Do you recognize what's shown in that photograph?
Yes.
What is it?
This is the trash bag that was inside the trash can where baby Evelyn was located, and also the child is with the aluminum foil and the blanket is laying beside the trash bag.
All right. So the body has been removed from the trash.
Correct. The
bag.
body's been removed from the trash bag. It's in the trash bag with trash in it. Baby Evelyn is laying there wrapped in blankets and aluminum foil wrapped around her.
Judge, we would move to make that exhibit 5 to this hearing. Do you recognize what is shown in the photographs that's been handed to you?
Yes, I do.
And what is that? A picture of it.
This is the body of baby Evelyn after she was removed from the trash can, placed inside of a body bag. She's lying there with blankets wrapped around her and aluminum foil wrapped around where her head area was.
Judge, we would make that exhibit 6 to this hearing. Do you recognize the photo that's just been handed to you?
Yes, I do.
What is shown in that photo?
And this is baby Evelyn laying in, still wrapped in blankets laying on a body bag, with her arm exposed, showing the onesie that she was wearing.
All right. Is that photo, that one of the photos that was taken at the time the body was recovered?
It is correct.
Judge, we move to make that exhibit 7 to this hearing. Lieutenant Fox, do you recognize what's shown in that photo?
Yes, I do.
What is that?
This is baby Evelyn after the blankets and aluminum foil have been removed from her body. It shows the position of her head and how she was laying when the blanket was removed.
Judge, we move to make that exhibit 8 to this hearing. Finally, Lieutenant Price, maybe one more photo and asking you to identify that photograph, please.
Yes, I can. This is a picture of Evelyn, one of the last known pictures. We know that when she was alive.
Judge, we move to make that exhibit number 9 to this hearing. Thank you, Lieutenant Price. If you would answer any questions Mr. Scott has for you.
No questions, Judge.
That's all the evidence is there.
Judge, Mr. Boswell would like to make an allocution.
All right. Now, Megan is going to make an allocution, which means she's going to speak. We all know about these allocutions. We all know how they go. We all know how angry they make us. So, brace yourselves, because we all know this is going to be absolute poppycock and it's going to make us livid. But we're going to listen anyway because that's what we came to do. So here we go.
I would just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn. That's all.
Okay. No. That's not going to be all. I know you wanted this to be like quick and simple and whatnot, but we're going to replay that because it's so ridiculous that I need to hear it twice. So bear with me. Now, let's hear it.
I would just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn.
So let's break this down. You got up there all smug, Like you were fixing to just read some people for filth, right? Read some people for filth. And then you start to cry. Get the fuck out of here, Megan Boswell.
That's all.
I need that. Hang on a minute. I need that clip of Icked Mel saying, put her in a cage. Or did he say put her in a cage or throw her in the cage? I can't remember, but it was hilarious and I need that.
No, sir.
I'm sorry. Judge, the state has, prior to this hearing, filed a notice of intent in regards to enhancing factors that we believe apply, as well as a notice of intent to seek consecutive sentencing, which is what we are asking the court to do. And we believe, based upon the seriousness of the offense, as well as the fact that Ms. Boswell is a dangerous offender whose behavior indicates little, no regard for human life, that she had no hesitation about committing a crime in which the risk of human life was high. But this court should bring those sentences consecutive to each other. And I want to touch briefly on the enhancement factors, and primarily on the one that I think just screams out in this case, which is the violation of trust. Truly, I think the facts that were involved in this case, and the court, of course, consider everything that was presented and that came in at trial, as well as the photographs that have been introduced to the sentencing hearing, which again, those were all part of the trial evidence as well. But the trust that Ms. Boswell betrayed upon her daughter was just so callous. She chose herself repeatedly, time and time again, over her child. All deaths are horrible, but for a small child to die in the way that Evelyn died just shows such extreme callousness. And those photographs show you. I mean, she was discarded like a piece of common garbage. Detective Lieutenant Price testified to, it looks like the body has been compressed, pushed down in the trash can, so we can fit more trash, more garbage on top of a child. But probably the most hurtful and severe part of this whole, and painful part of this, is the fact that all that occurred at the hands of the one person that she should have been able to rely upon and trust to protect her own mother. But Megan didn't do that. Megan repeatedly chose Megan. Megan chose her new life. Megan chose living in the big house out by the lake. Megan chose going to the movies. She chose going to Blowing Rock, going to Gatlinburg, again and again and again, over her own daughter. In order for the court to find that the defendant was a dangerous offender and apply consecutive sentencing, there are two things that the case law has said the court has to find. One is that it relates to the severity of the crime. And I can think of nothing that would be any easier than to relate consecutive sentencing to the facts of this case and what Ms. Boswell did. I mean, not only did she murder her own child and then go about her own life, but then once law enforcement was finally brought into the case, not because of her, not because she did anything, but because it finally got reported by her dad. Well, then she manipulates law enforcement, it manipulates the community by continuing to lie over and over and over again, causing extraordinary resources to have to be involved for weeks trying to find this child in the hopes that she's alive. And then even after that, even after she finally coughs up the fact that her child is dead, she continues to lie about not knowing where she is. When all along, she's sitting there stuffed upside down in a trash can in her childhood playhouse. So I think it's very easy for this court to find that the severity of this crime and her suffocating her own child, putting her in a trash can, and then repeatedly lying about it to cover it up relates to the severity of the crime. The second finding this court has to make is that it was necessary that consecutive sentencing is necessary to protect the public from further crimes. And I provided the court, as well as Mr. Scott, with the case of State v. Taylor, which was a case in which a small child had been beaten to death, and then the mother basically delayed in reporting, calling 911, which eventually resulted in the child dying because she didn't receive any medical attention. And the court in that case found that the dangerous offender classification was satisfied because the defendant had demonstrated extreme callousness towards the health and welfare of the victim, and the results were fatal. Well, Judge, I really, it does not get any more callous than what the defendant did in this case. You know, she turned her back, she turned her life, she turned her trust away from her own child. Evelyn got in the way of the life Megan Boswell wanted to live, and so she eliminated that problem. It truly does not get any more callous than that. So the state would submit that both those factors are met and that the court should impose consecutive sentencing. I've already touched on the element as far as trust being involved as an enhancing factor. And then sitting here listening to Ms. Boswell's rather brief allocution, I think it's also right for the court to consider the fact that she sits here today in this courtroom still having absolutely no remorse and taking no responsibility for the death of her child. Once again, she wants to make all of us victims in the case, make herself a victim. Sheriff's Office, I guess, should be issuing an apology to her for the way she's just been unfairly treated during this whole process. Judge, Miss Boswell was not treated unfairly. Her child was treated unfairly. Her 15-month-old child never had a chance because of the one person who should have protected her. So for that reason, the state is asking you to maximize her sentence in the remaining counts that she has to be sentenced on, and we would ask that they be run consecutive, Judge. Thank you.
Judge, I guess I'll try to address this in somewhat the way Mr. Harper did, maybe in a backwards fashion. Ms. Boswell had no prior criminal history when this case started, when the investigation started. At some point, she was convicted of a reckless driving B misdemeanor in Washington County, I think in February of 2020. That's the only criminal history she comes to this court with. She's been in jail since she was 18 years old. She will be in jail if this court were to sentence her at the low end of everything, and not run it consecutive, she'll be in jail until she's 69 years old. So the court then has to determine, is she, at that point, is she gonna be a threat to society? Does society need to be protected from 69-year-old Megan Boswell? The court should, I guess first the court has to consider the length of the sentence. She's a range one offender as to each count. The court should impose I think the sentence is, short of a sentence is as necessary, so the court is supposed to do, to achieve the purposes of sentencing. Here, she's serving a life sentence. She will be eligible for parole at 69 years old. So how much more do you need? Essentially, the state asks you to sentence her to life without parole. That's what they want.
I understand this is your job, Mr. Defense Attorney, and I ain't even gonna shame you for your job, okay? Somebody's got to do it. Let me just say this. Had your client not got up there and told God and everybody, including the court, how the state of Tennessee treated her so unfairly while she stuffed her daughter in a trash can upside down and wrapped foil on her head, around her face, and had blankets all over her, wrapped her up in blankets, and then put more trash on top of it, maybe she might have had a chance at not having them run consecutively. But at this point, throw her in the cage, put it consecutive, and walk away. I don't give a rat's fat kneecap if she's 69, 89, or 99. She has no remorse. She takes zero accountability, even after all this time. She deserves the maximum penalty, and they should be run consecutively. That is all.
And we have addressed that issue already in a manner of speaking. I guess, practice law 25 years, not the only jury sentencing I've ever done. But the jury had the opportunity, after hearing all these facts, to consider whether to sentence her to life without parole or life with parole. They sentenced her to life with parole. And I know you're not bound by that on these other counts. But I think in fairness and in deference to that jury, we have to give some respect to what determination they made. And they were aware of all the other charges. Obviously, they heard the guilt phase on those and convicted her.
Yes, they did. They heard all of that. They heard all of the evidence. You know what else they saw? They saw Megan Boswell over there in the defendant's chair, crying with a great big ass bow in her head and all of the things, and she appeared to have some type of remorse. I guarantee you, if you brought all 12 of those jurors back in and sat them down and let them listen to that allocution that your client just made, they would change their minds.
So I think that is important to consider. She's eligible for probation on all the other charges. The court has to make a determination whether or not those sentences should be suspended or served. The court has to make a determination whether, if they are served, how they're served, consecutive or concurrent. As it relates to the dangerous offender who society has to be protected from, I think the case law is quite clear. Not every person convicted of first-degree murder and another felony is going to fall into that category. Normally, in a lot of the cases you see multiple victims, multiple acts. Here, all those things kind of go together. And I guess the other thing we have to talk about is what counts merged together in this sentence. I would suggest the court that the murder counts merged together for one count. That the child abuse and child neglect counts should merge. And that all of the following false reports should merge. Because I sent a case to you yesterday. State versus Smith, 436 Southwest 3rd, 751. Tennessee Supreme Court decided that in 2014. He talks about cases just like this. Each of these cases, these interviews were basically a continuation of the other interviews. And based on the rule of leniency, the court found that even though in that case interviews were made over multiple days with different officers, just in this case that they had murders. And that's what I think should happen here, is all those counts should merge. And I guess finally, I want to address what Mr. Harper said about Ms. Boswell's comments. I think a lot of defendants would probably feel that way. But I think she's entitled to maintain her defense. She doesn't have to come in here for purposes of sentencing or this, and somehow take responsibility. The law doesn't require that. That's not one of the factors to consider for consecutive sentencing. That's not one of the factors to consider for length of sentence. The defendant has a right to maintain their innocence, and to hold that against them and to somehow sentence them to more jail time because they don't come in here and say, I did it. That violates due process. It violates the right to trial by jury, the right to appeal. So I would suggest to the court that the appropriate sentence here should be bottom end of the range. The sentences should run concurrent, and ultimately she should be left with a chance of parole when she's 69 years old, however that is structured.
Court will be in recess for 15 minutes.
All right. I'd like to address some of the comments made by the defense attorney. And he's not wrong. Megan doesn't have to come in there and show, say that she did this. She is appealing her sentence. I mean, she did file motions for a new trial. That's true. In that case, my advice would have been, shut the fuck up. Don't say anything. Don't make it, don't make it worse. But the reality of the situation is also this. In order for one of the components necessary and required by the parole board for Megan to even be considered for parole, one element is that they're going to want her to take account. The parole board will want her to take accountability. The parole board will want her to say, yes, I did this. I am deeply remorseful, deeply sorry. I violated the trust of my daughter, the most precious gift ever given to me. I had a rough upbringing. Part of when she was pregnant with Evelyn, she was in the system. She didn't get pregnant with Evelyn in the system, but she was put in the system mainly for truancy. I feel like we didn't hear all of those. I don't feel like we heard all of the circumstances that led up to her being removed from her home, but she was. And that is not an excuse. Youth in this situation is not an excuse. Hey, thank you so much, Sky Flashed. I appreciate that. Thank you very, very much. I appreciate that. I don't know about the victim impact statements because there were two parts to her trial. One was the guilt or innocence phase, and then there was the then there was the sentencing phase. What did the jury, what was the jury, they deliberated and recommended the sentence. So I feel like there might have been victim impact statements then, because I think if there were going to be victim impact statements today, they would have been made before the judge recessed the court for 15 minutes so that he could make his decision. So I really, I don't think we're going to hear any more than we already heard. And if you want to hear those again, I made a playlist on the channel, and the playlist is arranged chronologically. So day one of the trial all the way through to the end. But youth is not an excuse. I've seen comments in the chat while the trial was happening. I've seen them today. I have personal experience with this. When I got pregnant with my oldest son, I turned 18 January 28th of 1995. I found out that I was pregnant the last day of April 1995. I was 18 years old and 4 months. I had decisions that I had to make. And the decision that I made was to raise my son. Now, when I made that decision, did I know all of the things that could potentially happen along the way between being pregnant, then having the baby, then raising a child for 18 years? Of course not. I was 18 years old. But let me tell you what I did know. What I did know was that I was going to do everything in my power to take care of that child. And did I take care of, like, financially? I wasn't as stable at 18, obviously, as I am now. Okay. I wasn't as stable at 18 as I was when I had my fourth child. I was, I was young. I don't regret it. I don't regret my decision. And yes, crocheting Bammy, it was a huge decision being born and raised Catholic. Although I will say this, my situation respective to my family was a little different than Megan's situation. I had support, but my parents, they're boomers, all right, and I'm Gen X. I was raised, the support was tough love. If my son needed anything and I couldn't provide it financially, my parents would help, but they were a call that I made as the absolute last resort because I knew. But once I made that commitment, it was the commitment that I made. Now, if at any point I ever felt Megan had options, and the fact of the matter is she was raised, she did spend some time in the quote unquote system. And so I don't know, and her, the family that fostered her also helped with Evelyn. And I feel like she had resources that were available to her that many teen moms actually don't, because they don't know anything about that. They don't know that those resources exist, but Megan did. And at no time did she ever say, I'm overwhelmed, I need help. She didn't. What she did do was consistently, continually lie and blame other people. She blamed her then boyfriend, not the father, of her child, of Evelyn. She blamed him for Evelyn's death. Then, even before that, she lied to another boy. At the time, he was a boy, and said that he was the father. And it turns out he's not the father. Megan isn't even the one that reported her daughter missing. And a lot of her behavior during the investigation, the lying, and all of it, suggests a level. Now, I'm not saying that the lies themselves were sophisticated, because they weren't, but the behavior, the lying in and of itself, the immediately being confronted with the lie and doing the quickest, without barely blinking an eye, pivot to another story, suggests a level of sophistication that is beyond her 18 years. And I think that should be taken into accountability. What are we needing recap, babe? Hold on a second. Allie needs a recap. Hold on a minute. I mean, Skyflash is not wrong. Gen X childhood was in the streets. We were responsible for our survival and our peers out there. And she had no connection to the life she gave. She saw no value to herself. I just need you to tell me what recap you need, babe. Oh, okay. What you've missed in the last few minutes, the judge called a recess. Hold on, let me push pause. We're about to hear it. The judge called a recess to deliberate over what her sentencing should be. The state wants it to be consecutive, which is one sentence after another. The defense not only doesn't want it to be consecutive, he wants the minimum, and some of them he wants probation for, and a lot, and them to be merged. And so the judge said, well, I need a 15-minute recess, and then I'm going to come back and tell you what I'm finna do. So now that's where we're at. You haven't missed anything important, just me kind of blah, blah, blahing. Oh, and the defense's argument for why they shouldn't run consecutively is because she'll be 69 when she gets out. What kind of threat could she possibly be? And that they should, the judge should give respect to the jury's decision that her sentence be, she be given a chance at parole. And if the sentences were to run consecutively, that's effectively a life without the possibility of parole decision, and that her allocution shouldn't be held against her. She has a right to maintain her innocence. She also has the right to remain silent, but she didn't exercise that right either. Just saying. Yes, Rando, or no, Violet. Look at Aunt B. Aunt B chunked a whole woman over pushed a woman so hard she fell over a recliner. Old people, listen. It ain't the age of the dog in the fight. It's the crazy in the dog in the fight. Okay. You push somebody. You never know what you're gonna get. I don't know why we're at a sidebar. I don't know how Megan can put them dirty paws in her mouth. That's for sure. She ain't showered in a month of Sundays. Look at the hair. It's not just about a brush. It's about cleanliness. I don't know why I'm yelling. You know what, Sarah? She was. Sarah said she was so joyously flippant and cutesy during her statement. You know what it reminded me of? It reminded me of the interview with the news that she did out in front of the police station. Oh, Double M, thank you. That's so generous of you. I appreciate that. Double M says, always great, Jen. She just walked away from her daughter when it wasn't convenient. Then lied so hard for me to have grace being a teen mother who struggled. It's very difficult for me as well. And thank you. That was incredibly generous and I appreciate it so much. It's very difficult for me to have grace. You know, very. Because she didn't even try. Oh, babe, you are so welcome. Anytime, Allie. I'll always catch you up. Don't you worry. I got you. Judge is just looking over things, making sure all the I's are dotted and the T's are crossed. I'm gonna see if I can find Megan's appeal. We'll go over that another day.
Appropriate sentence for these offenses. The court has considered the evidence presented at the trial at this sentencing hearing. Pre-sentence report filed April 4th, 2025, more than 10 days ago. The principles of sentencing and arguments made as sentencing alternatives, the nature and characteristics of the criminal conduct involved, the evidence and information offered by the parties on mitigating and enhancing factors, any statistical information provided by the administrative officer of the courts as to sentencing practices for similar offenses in Tennessee, located at www.tncourts.gov, and any statement the defendant has made on her own behalf about sentencing and the defendant's potential for rehabilitation or treatment. I'm not sure if it was agreed, but the defendant's a range 1 standard offender under Tennessee felony classification laws. And what that means, the aggravated child abuse and neglect charges are Class A felonies, and as a range 1 offender, those would carry somewhere between 15 and 25 years. The tampering with evidence is a Class C felony. The range would be between 3 and 6 years. False reports are Class D felonies, with the range 1 being 2 to 4 years. The abuse of a corpse is a Class E felony, and failure to report death under suspicious, unusual, or unnatural circumstances, also a Class E felony. Those Class E felonies for range 1 would be a range of 1 to 2 years. In determining where the appropriate sentence should be within that range, while not mandatory any longer, the enhancement factors and the mitigating factors are advisory for the court. The state has urged in its filing state's urged number 3, enhancing factor 3, that the offense involves more than one victim. I think for purposes of this case and all the proof that I heard, I can understand how that argument could be made, but I'm not going to find that enhancing factor number 3 applies. Enhancing factor number 4 is urged by the state. A victim of the offense was particularly vulnerable because of age, physical or mental disability. I think that will apply. Testimony was that baby Evelyn was, everybody keeps saying 15 months old. I think she was 15 months old when she was found. My recollection of proof was that she was approximately 13 months old when she went missing. Is that wrong?
Her approximate age at death was 15 months old,
At death?
at death.
Okay. So she was 15 months old.
It was 13 years,
It was 13.
13 months old at death. It was 15 months old, they assumed when she was reported. When they didn't know she was alive or dead.
So at the time of her death, she was somewhere between 13 and 15.
Yes.
The state, the court accepts enhancing factor number 4. Number 5 is urged by the state. The defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. I don't know, and I'm not going to sit here all day and regurgitate the facts from the 11-day trial. But thinking back on the proof that I heard, there can be no more cruel act than to stuff a 13 to 15-month-old baby wrapped in blankets and aluminum foil head first into the trash can. Especially when that 13 to 15-month-old baby is your baby. So the court accepts number 5. Number 6, the personal injuries inflicted upon or amount of damage to the property was particularly great. The court accepts number 6. There's no greater injury that you can inflict on another human being than death. Enhancing factor 10 was in the filing. The defendant had no hesitation about committing a crime when the risk to human life was high. The court accepts number 10. And then 14, the defendant abused a position of private trust. And again, the relationship between mother and child, there can be no greater private trust on this earth than that. So the court accepts number 14. Those are all the enhancing factors that were urged, all the ones that the court, after having looked through them, believes applies. Next, I have to consider mitigating factors in determining the appropriate length of sentence. And again, I'm not going to read, there's 12 statutory mitigators under 40, 35, 113. I'm not going to read all of these in. The defense didn't put any arguments forward as to any mitigating factors that should apply. The court, though, is required on its own, after having read the pre-sentence report, heard the proof, to apply any factors I think are applicable. So there's at least one that could be applicable, and I'm going to talk about it for a moment. If the defendant, because of youth or old age, lacks substantial judgment in committing the offense, the proof is that she was 18 when the killing occurred. But I also have to look at, so there's no question that she was a young adult. But I also have to look at all the other proof and circumstances surrounding the case. And it became very clear to the court upon hearing the evidence that the defendant, in her mind, saw a chance to lead a different life than what she thought she was going to be leading. And quite frankly, circumstantially, from all the proof, baby Evelyn was a stumbling block to leading that life. So she made the decision to remove that stumbling block. And because that's the tenor of the proof that this court heard, I reject mitigating factor number 6. She exercised judgment. It wasn't good judgment, but she exercised judgment in doing the things that she did. So of the 12 statutory mitigators, the court doesn't find that any are applicable to this case. The 13th.
All right, I got to pause for just some fair use commentary. Neat Noodle says you can go to Ward 18, enter a contract, work, etc. This isn't going to cut it. It definitely is not going to cut it. And Skyflash Photographer says, thank you very much for your super chat, by the way. It was very generous. I appreciate it very, very much. When do we discuss Wendy and Lacoste upcoming showdown? Not to distract from this doofus, but an entire family is going down before our eyes. Well, maybe I'm having a members live this weekend. I'll put that on the agenda and we'll discuss that this weekend for show. Thank you for your super chat. I appreciate it very, very much. All right.
Is any other factor consistent with the purposes of the chapter? And courts regularly, if a person comes to the court without a substantial criminal history, courts regularly include that as factor number 13. If a person comes before the court and they've had a long, productive work history, then that factors into 13. If they've had military service, those are the kinds of things that factor into 13. In this case, Ms. Boswell, she did not have a long work history. In fact, the pre-sentence report said, she stated that she'd only ever had one job in her life, and that was at the chicken shack where she was working right around the time of this killing. I am going to give her credit for not having, even though she was only 18, I'm going to give her credit for not having a substantial criminal history, either as an adult or a juvenile. So, when the court weighs all the facts that I've heard during the trial, all of the testimony that we've heard at this sentencing hearing, when the court weighs the enhancing factors and the mitigating factors, that's how I arrive at or not a verdict, but a sentence. I do want to talk, and I want to talk about each of these counts individually with regard to the enhancing factors. Because if an enhancing factor is part and parcel of a charge, then it can't be used as an enhancing factor.
Okay, so what he's saying is, I think, the charges alone. So she is got 19 other 19, I think, other charges, or four, no, he said 4 through 20. So that's 16 other charges that that they're talking about. And so the charges are just the charges, and they can't be used as enhancing factors, is what I think the judge is saying here. All right.
Count 4, aggravated child abuse. The state has to prove that the defendant knowingly, by other than accidental means, treated a child under 8 years of age in such a manner as to inflict serious bodily injury. The court is of the opinion that number 4 still applies because of the tender age of the child at the time. It's one thing to be a child under 8 when you're 6 years old or 7 years old. It's quite another thing to be vulnerable because your age is still literally being counted in months. So the court finds number 4 applies. Number 5 is not an element, it applies. Number 6 applies due to the death is not an element of aggravated child abuse or aggravated child neglect. 10 and 14 apply. So the court finds that they all apply to counts 4 and 5. So the court's of the opinion in that Class A felony that the enhancing factors and the aggravated nature of this case in general take that sentence from 15 to 25 years. And when the court weighs, and quite frankly, each of these enhancing factors, with the exception, number 4 has low weight because of its similarity for those 2 counts, to the charge. 5, 6, 10, and 14 have great weight. The court affords very little weight to the fact that Ms. Boswell, at 18 years of age, had no serious criminal history.
So he's saying right now that
So the court's of the opinion,
what he's saying is for the aggravated child abuse charge, the aggravating factors far outweigh a mitigating factor, which would be the lack of criminal history.
in counts 4 and 5, that the sentence should be 25 years.
That's the maximum he can give on that charge. 25 years she got on aggravated child abuse.
The court's also of the opinion that count 5 merges into count 4. In the tampering with evidence, the court's of the opinion that all the enhancing factors should be afforded great weight, and the sentence should be 6 years.
All right.
The mitigating factor, which is the court's been giving very little weight, would not bring it back down.
So rather than, okay.
Now, with the false report,
All right. Oh, wait, hold on. Let me let him finish.
the court's of the opinion that
Oh, wait, hold on. So what he's going to do is every count that she got for lying or tampering with evidence, rather than sentence her to each individual count, he put all of the counts together. And again, the aggravating factors outweigh the mitigating factors. And now he's going to get into the lying.
Now, with the false report, the court's of the opinion that the enhancing factors would take that sentence from 2 up to 4 years. And again, there being only the one consideration of the mitigator, it'll be 4 years. Under the case of State versus Smith, Tennessee Supreme Court 436 Southwest 3rd, 751, handed down in 2014. Justice Holder, I believe, delivered the opinion of the court. And the opinion of the court was that due to the principle of lenity, not leniency, that a false report, because the legislature was ambiguous as to how they think that a false report should be punished, that the unit of prosecution isn't determined by the number of individual and distinct occurrences of false statement, but that the unit of prosecution is whether a false statement was given pursuant to a particular incident or offense. At least that's the way I read it. So it wasn't that it's a continuation of the interview. It's that the incident that is in the officer's concern is the disappearance of the child. And the Supreme Court says in that case that even if you tell 16 false statements about the disappearance of that child on different days and to different people and different variations of the story, it's still one incident. It's the disappearance of a child. So counts 7 through 17
That's 10 counts of
all merge into one count.
lying
So
to
they all merge,
cops.
counts 8 through 17 merge into count 7. In count 19, the courts of the opinion the enhancing factors take that sentence from 1 up to 2 years. So that'll be a 2-year sentence. In count 20, and again, I'm weighing the lack of mitigators. In count 20, that sentence will be 2 years as well, for the same reason. Now, since I've already talked about merger, the courts of the opinion that counts 1, 2, and 3 would all merge into a single life sentence. So counts 2 and 3 merge into count 1. Now we'll talk about consecutive sentencing. In the state's filing, the state under 40-35-115 urged, and I think this might be a mistake, but urged number 2, that the defendant is an offender whose record of criminal activity is extensive.
And of course, ruling, I just so clarify, it wasn't a mistake, but at the time it was filed, when we would have all the false report counts, rely on false criminal history, obviously since the court's stronger, multiplicitous, that doesn't exist anymore, so we're not relying on that one.
The court rejection. But the court also relies on enhancer number 4 from the same statute, 40-35-115, that the defendant is a dangerous offender whose behavior indicates little to no regard for human life and no hesitation about committing a crime in which the risk to human life is high. Now that's what the factor says.
Just pause for a brief fair use commentary. Bogart, thank you for being a member for 9 months. I appreciate that very much. I believe Crocheting Bammy's math is correct. That is 39 years. Now we'll see how she's to serve these. Will it be consecutive or will it be concurrently? Now she got the maximum sentence on he merged several counts of the lying to police and tampering with evidence. And then he merged the murder charges, which was first-degree murder, felony murder, and I cannot remember the third one. They're all merged into the one, I believe, first-degree murder. And we'll see how it goes.
in the statute. But it's pointed out in State versus Taylor, (2017) Westlaw 2179952 also.
Well, so Allie wants to know, 39 years, how much is that if she's good? Well, it depends. We don't know yet because we don't know how he's going to sentence, how they're going to be served. That's really the determining factor here. Is will she have to serve them? She was 18 at the time. This happened in 2020. So she's 23 or 24 now. She might have just turned 24.
Case numbers M 2015-02142-CCA-R3-CD. It's an unpublished case, but the unpublished case references published opinions. And the most important one that it references is State versus Moore, that quotes from the main case is the Wilkerson case, 905 Southwest 2nd. (933) Tennessee Supreme Court from 1995. And the Supreme Court, in determining the appropriateness of 4035-115, enhancing factor number 4, states that in addition to what's stated in the statute, that a court must also find that a sentence, consecutive sentencing, is necessary in order to protect the public from further misconduct by the defendant, and that the terms are reasonably related to the severity of the offense. So, from the facts of this case, and again, I'm not going to just keep repeating it. Everybody who sat through that trial knows the facts that came in.
Yes, Neat Noodle. That's just 39 years on these charges. She's sentenced murder separately, yes.
If that child was suffocated. When you look at the pictures of how tightly this baby was wrapped in blankets and aluminum foil, and the mechanism of being stuffed into that trash can head first. There's no doubt in my mind that this defendant had absolutely no hesitation when she killed her daughter. And in hearing the proof during trial of how she continued to live her life, and from hearing the proof circumstantially as to why she might have done this deed, because this new boyfriend is the life that she wanted to grasp onto. It's like the state said, the house on the lake. A lifestyle that she wanted for herself. The fact that Evelyn was just in the way. And looking at all the video that we saw during the trial, this court never once saw remorse, never once saw empathy out of the defendant. So she is a dangerous offender. The circumstances surrounding the commission of this offense are absolutely aggravated. This baby couldn't care for herself. This baby had the only life this baby knew. The only way this baby could get through a day was through her mom. And I understand that the way the parole system is set up when dealing with a life conviction is that she has to serve 51 years before she's even eligible for consideration for release. And Mr. Scott asked the question during his argument, which was the right question to ask. Is Megan Boswell at 69 years of age coming out of prison a risk to society? And the only conclusion that I can come to after hearing the proof in this case, seeing the evidence in this case, seeing how utterly unconcerned with the fact that she took the life of a 15-month-old child, her own child, the court has to answer that question, yes. That society does need to be protected from the evil that lurks in her heart.
The judge, Kelly, the judge is speaking, babe.
And then would the aggregate length of the sentence reasonably relate to the offense which she stands convicted? For the same reasons I just said, yes is the answer. So the court finds that all those sub-factors, if you will, are met. And I want to read a passage. And I think the state may have, but I highlighted this yesterday when I read the case. In State versus Durantes, 331 Southwest 3rd, 370, at page 376, the Tennessee Supreme Court in 2001 found that the dangerous offender classification was satisfied where a defendant demonstrated extreme callousness toward the health and welfare of the child victim, and that the results of that callousness were fatal. It's almost as though that passage was written to describe this case. Therefore, the 25-year sentence for the merging counts of aggravated child abuse and neglect will be consecutive to the life sentence. The 6-year sentence for tampering with evidence and the 4-year sentence for false report will be concurrent with each other, but consecutive to the 25 years. And the 2-year sentences for the abuse of corpse in count 19 and count 20 will be concurrent with each other, but consecutive to the 6 years. So in counts 4 through 20, that'll be a 33-year sentence as a range 1 standard offender, consecutive to her life sentence. The court has considered probation. She's not eligible for probation on the Class A felonies. That 25 years has to be served by statute. The court has considered probation on the additional 8 years and finds that a grant of probation would depreciate the seriousness of this case, given the facts of this case, given the fact that she has shown no remorse, she has shown no empathy towards this child, her child, and probation in those counts will be denied. Mr. Scott, I believe at sidebar, you had indicated that you would like to have a transcript prepared before, in order to prepare the motion for new trial.
Yes, Judge.
I'll order that transcript, whatever order I need to sign, Sherry, I'll do it.
Judge, I would also like to have this sentencing hearing as well.
Sentencing here, let me get it typed up as well. We'll set this for status.
Why is there a status?
We'll
Hold on a
send
minute.
Ms. Boswell back to TDOC. And let's set this for a status on
Oh, I know what it is. I'll tell you in just a sec.
January 16, to see where we are on getting the transcript prepared.
That's fine, but I'll waive Ms. Boswell's appearance at that.
Well, what I prefer her to do is appear by Zoom.
That's
If-
fine.
If she can, but if not, yes, we can.
Okay.
All right. All right, that's all.
All right, so she got 25, 6, and it was 33 years total, okay? But some of the 33 will run concurrently with each other, but all of them have to run consecutively to the 25. Plus, she's got the life with the possibility of parole at 51. But that it was, so she has that, but that is going to run, but the 25 years runs consecutively to the life with the possibility of parole. So essentially, it is life without the possibility of parole because she has to serve the next okay, so after she does the life at 51, right? For the when she would be eligible for parole at 51, she can apply for the parole, right? And let's say they grant her the parole. It doesn't move anything because she must do the 25 years. So even if she were 69, no, more than 58. It's 51 plus 25. So what is that? 51 plus 25 is 66 years. No, 76 years. Let me do the math. What did I say? 51 plus 25. 77 years. 76 years. She gets 76 years. So what will have to happen is, all right, she'll have to do 51 years on the life sentence. Okay. She can apply for parole. All right. And even if it's granted, she still has to do 25 years after that. So if she is 69 with the life sentence, plus 25 more years is 94 years old. The bitch ain't getting out. She's not even eligible for parole until she's 69 years old. And after that, she will still have to do the 25. The 25 years must be served because he sentenced the 25 to run consecutively to the life. She will be 94 years old. She's never getting out. Patricia says she will be eligible for parole at age 51. No, she was 18. So they go back to the 18 years. Okay. And she'll have to serve 51 years. 18 plus 51 is 69. She has to serve 51 years of her sentence. So they kept saying she'd be 69 years old before she's ever eligible for parole. They said it like 27 times. So she has to serve 51 years. I guess she got some credit for time served, right? Yeah. She got credit for being in jail pre-trial. She was arrested at 18. She got credit for that time. So 51 years from the time she was first arrested, first incarcerated, would be 69 years old. Not when she's 51 years old. 51 years later is what they said. So that's it. That's all. That's what she's getting. 69 plus 25. Or 51 plus 25. So what is that? 51 plus 20. We already did this math. Let me just get the calculator again. 76 years all the way. So this happened in 2020 when she was 18. Today's 2025. So what does that make her? 23, 24? Let me just find. Hold on. Hold on, Patricia. You don't have to go anywhere to check it out, babe. I'll put it right here for you. Hold on. It's right here.
Of what Mr. Harper did maybe in the back of the fashion. Ms. Boswell had no prior criminal history when this case started, when the investigation started. At some point, she was convicted of a reckless driving B misdemeanor in Washington County, I think in February of 2020. That's the only criminal history she comes to this court with. She's been in jail since she was 18 years old. She will be in jail if this court were to sentence her at the low end of everything, and not run it consecutive. She'll be in jail until she's 69 years old. So the court.
So what the defense attorney just said right there is she will be in court or she will be in jail, in prison, until she is 69 years old. And that would have been only if the sentences were to run concurrently, but they're not. She's eligible for parole after 51 years, not when she is 51 years old. Am I wrong? Am I hearing it wrong, you guys in the chat? Help. Because I don't want to be wrong. I don't want to tell you guys wrong information.
Then has to determine, is she, at that point, is she gonna be a threat to society? Does society needs to be protected from 69-year-old Megan Boswell. The court should, I guess first the court has to consider the length of the sentence. She's a range one offender as to each count. The court should impose I think the sentence is, short of a sentence is as necessary.
Yeah. Let's go back to Megan's ridiculous allocution, please. Where did it go? No. What, that cop snatched her up quick? You're welcome, Patricia. Look, there was a lot of numbers in there, and I'm shocked that I even got it right, okay? And I think 99.99999% of the reason I got it right is because I used my calculator. All right, here we go.
I would just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn. That's all.
I'm sorry.
Can you believe, y'all, she had the unmitigated gall? The unmitigated gall to get up there and say that. The state of Tennessee treated me unfairly. They did not. Man, shut your clown ass up. Such a liar. They treated her really fairly, actually. They did. They entertained her BS. Even after everything, right? When she sat there and she sent them on the first wild goose chase, which was that her mom took the baby. That was the first wild goose chase. All right. The second then wild goose chase was that, okay, I'm going to tell you the truth. Hunter did it, but he took the baby, he took Evelyn out of the trailer and he did something with her, and I don't know what he did with her body. So then she comes up with, 37 places. I don't know how many places, but it was, at least 2 places too many, because it was never her property. It was always Hunter's family's property for them to search. That was another wild goose chase. Okay. That they sent her on. Then we have the testimony from the second medical examiner. Okay. And she testified that it was her opinion that Evelyn Boswell was still alive when she was placed in the trash bag with trash in it, in the trash can upside down. And I think that is a reasonable conclusion, because why else would you need to wrap a child's head so tightly in blankets and foil that the baby's face left a permanent impression in the foil. Also, it's the other act of placing her upside down. Evelyn was walking, and I would say that Megan placed her upside down so that she could not get out of that trash can. So she was particularly cruel. Can you imagine what that child must have been going through? The fear. First, to have her little face wrapped in foil, blankets. And then to be stuffed in a smelly trash bag with trash in it. Then shoved upside down into the trash can. And then suffocation is not a quick, painless death. She's a piece of shit. She deserves exactly what she got. She is not one. And there have been people that have been sentenced to life with the possibility of parole who I have argued both ways that they don't deserve a shot at parole. Susan Smith, we're looking at you. And then ones that do. Andrea Yates. I believe that Andrea Yates, had she not gotten pregnant the last time, had and been on her medication. See, she couldn't take her medication while she was pregnant, and she couldn't take her medication after she gave birth because she breastfed. And it is what turned her postpartum depression into the very rare postpartum psychosis. And even Andrea Yates, who is eligible to be released, never pursues it. She doesn't want out. So it's not like I'm just, lock them up and throw away the key forever. There are circumstances, there are crimes where the person, I do believe, can be rehabilitated. This ain't that, though. Megan cannot. You cannot fix what you don't acknowledge. And I really don't all the time. I don't really actually care for Dr. Phil, but that one sentence, you can't fix what you don't acknowledge. I mean, I could probably put it a different way and not quote him, but the truth of the matter is that just makes logical sense. If you don't think you have an issue, if you don't think there's anything wrong, then why would you change? And Megan doesn't think she did anything wrong. She doesn't. In fact, not only does she not think that she did anything wrong, like she could not even take accountability for the lying. She took no accountability for anything. Because even if she were to be believed, which obviously she's not, but let's just for a second entertain that, okay? Even if she's not the one that's guilty of killing Evelyn, that her story about Hunter is 100% correct. She's guilty of lying to the cops because that's not what she told the cops. She told the cops that her daughter had been kidnapped. And she didn't even report it. She reported none of it. She didn't report that Hunter had killed her daughter. whether it was an accident or not, she didn't report the death, and she lied to the cops once they confronted her about her missing daughter, who was reported missing by her father, Megan's father, Evelyn's grandfather. She couldn't even acknowledge any of that crap. She'd acknowledged nothing. She took no accountability for anything. And maybe at 69, she'll be ready to take some accountability, but it won't matter anyway. She'll still have 25 more years to do. All right. That is all I have for you guys. I think ATS is planning on doing a live tonight, and she has very graciously invited your girl to be part of the panel, and I have accepted. So that is what I'll be doing tonight. I think it's either tonight or tomorrow. Oh God, let me look. Sorry, ATS. Okay, hold on. Let me look. Oh, yes. And then there's a Watts question and answer on Sunday. There's 2 nights. Friday. So on Saturday, I'll do the members only live. Okay. I'm going to try to figure out a way, Chief, to get you a membership. Okay. Because you need it, dadgummit. All right, you guys. Thank you all so much for being here. And for that members only live, I'm very excited. I'm very excited about that because I'm going to stream through StreamYard so you guys can come up on panels. So StreamYard's an easier platform if you guys want to. All right. So take care. Have a great rest of your day. And I will see you all over at ATS News tonight. All right. Bye.